Thank you. Please be seated. So the only case on our docket this afternoon is Ruybalid v. the Board of Commissioners, County Commissioners of both Huerfano and Los Animas counties. I see council sitting at table as if they're all ready to go and know what they're doing. It wasn't entirely clear to me from orders I've seen. Will you all be splitting time, or will one be doing the argument?
Yes, Your Honor, we'll split the
Okay, and we'll leave that up to you then. If you can get out of our clutches while you're up here. Very good. Then if we're all set, counsel for the petitioner, when you're ready, please begin.
May it please the court. There's an adage that I imagine...
Counselor, just introduce yourself for the record.
I'm Stephen Jensen, attorney registration number 14141. I've entered a special limited appearance on behalf of Mr. Ruybalid. I'm normally a chief deputy district attorney for the 1st Judicial District.
And counsel, just so you'll know, we record these things, so if you can stay somewhere close to that microphone, that'd be good.
I will do, Justice Coates. There's an adage that we probably all heard for the first time when we were in law school, in my case, some 35 years ago, but it is that bad facts make bad law. It's a recognition of the principle that when confronted with cases that have bad fact patterns which offend the sensibilities of courts, there is a tendency to interpret the law against the bad facts which offend the court. The problem with that tendency is that it leads courts to deviate from the proper interpretation of the law. It puts personal opinion above the statutory language, and this tendency violates the foundational principle that we are governed by the rule of law. In this case, the Court of Appeals decision is an alarming example of the bad facts make bad law rule. Because the Court of Appeals took a critical view of the conduct of the petitioner, the court has interpreted the statute in question in a way that prevents recovery for the petitioner. In so doing, the court has ignored standard rules of statutory construction and, in our opinion, has done violence, actually, to the meaning of the statute. The sense of disapprobation is evident in that opinion from the very beginning of the opinion, from its characterizations of the petitioner's conduct to the use of the phrase that the petitioner believes that the county should be on hook for the fees. And then if you look at the 4th footnote in that opinion, the opinion appears to dictate, suggest to the legislature that there is a desired course of action that the Court of Appeals would like the legislature to pursue so as to deprive petitioners like Mr. Ruybalid of recovery. That footnote reads, footnote 4, for instance, the General Assembly could condition reimbursement on whether a district attorney successfully defends against the disciplinary charges or on whether the disciplinary charges are without factual or legal basis. I would submit to the court that the opinion reads more like an attempt to spank the petitioner for unethical behavior in the case below, as opposed to a well-reasoned decision.
Counsel, can I just jump to a question?
Sure.
So our statutes provide specifically when a specific time when a public entity will be liable for attorney's fees on behalf of an employee of that entity. And there's a very specific system for determining when those fees will be available. The requirements of the Governmental Immunity Act were not met here. Is that correct?
I believe that is correct because I don't believe the terms of the Governmental Immunity Act would have been met by the litigation in question. That act, by its terms, deals with tort actions, and it deals with actions for recovery of damages for injuries. And as such, this act would not fall under that act. And so I agree with you, Justice Hart, that in the context of personal injury lawsuits, or lawsuits of that nature, yes, the legislature has said government officials are entitled to have attorney's fees paid, and it has dictated the circumstances.
Would that provision also cover, you mentioned personal injury lawsuits, but wouldn't attorney's fees be available, for example, if rather than being charged by our disciplinary system, if he had been sued for malpractice or sued for bad faith prosecution, sued for some kind of violation of constitutional rights, attorney's fees could be covered under this provision, right?
I believe only if it was an action which would be characterized normally in tort and which resulted in a claim of injury. That's my reading of that act. Actually, to a certain extent, if what Justice Hart is suggesting is correct, Mr. Ruybalid could have simply invoked the provisions of that act, and we could be arguing that before the court now. But unfortunately, because of the way the act reads and the scope of that act, that wasn't available to Mr. Ruybalid. And it certainly does, though, Justice Hart, show that at least when it comes to lawsuits against public officials, that the legislature is not opposed to the concept that that counties and other governmental entities should be responsible under appropriate circumstances for picking up those fees. But unfortunately, it is a limited act, and that's why we have to look at the act in question, the one that was interpreted, that is 21303 of the Colorado Revised Statutes.
Well, turning to that, Mr. Jensen, and let's assume 21303 applies. Tell me how the expenses at issue here were necessarily incurred and how they benefited the county.
And so, so two things. Okay, the expenses here clearly were necessarily incurred because we were talking about acts. Every one of these grievance allegations which were filed against the petitioner involved essentially claims that arose out of discovery violations, and every one of the acts or something that occurred as a result of his actions as a prosecutor in prosecuting individual cases. And this is not a case or a situation where the petitioner is being accused of engaging in unethical behavior outside of his practice of law and outside of his performance of his duties.
But as I understand it, I'm sorry.
No, go ahead.
As I understand it, the way this works, I mean, and people in public service get complaints filed against them, it happens. But here, ARC does a screening process, and I don't know, I'm not going to use the right words, I forget what they call it, but not necessarily finding probable cause, but they went to the next step. And so I could sort of understand, yes, he's subject to complaints because he's the DA, that happens. But when they go to the next step, and now he's defending something that the ARC says there's some merit here, I'm having trouble with a rule that says it's necessarily incurred, because at some level we'd be saying, he necessarily had to engage in unethical conduct.
Justice Gabriel, Mr. Ruybalid is an elected official, elected by the citizens of Los Animas and Huerfano counties. And it's a position, a constitutional position, but it requires that he have a license to practice law. And without a license to practice law, without the privilege to practice law, he cannot perform his duties. The complaints which were filed, which arose out of his handling of the cases, threatened his ability to practice and perform the constitutional responsibilities he has pursuant to that elected office. If he had simply not defended, then he would not have the qualifications to continue to do his job.
Do the counties pay for his for any CLEs that he takes?
The counties did not, I don't believe, but
Did the counties pay for his annual dues to this court?
He was given a budget, and those things were paid out of the budget. For instance, he would attend Colorado District Attorney Conference trainings, which would be paid for out of his budget. His staff would do that as well. I believe, and I'm not sure whether he himself paid his annual dues or whether that was paid out of his budget. In Jefferson County, it's paid for out of our district attorney's budget, but I'm not sure how it was done in Los Animas County.
So, are you finished?
Yeah.
Mr. Jensen, I guess I'm still struggling with the word necessarily. I mean, I understand that he needs to have his ticket in order to be able to practice, but necessarily sort of begs the question of whether it's necessary in a sense to engage in something that's ultimately found to be professional misconduct in order to discharge those official responsibilities. Help me with that.
Sure. Well, in the actual phrase is necessarily incurred.
Right.
In the performance of those activities. And so the actions he took were all part of his responsibility as a district attorney. And unfortunately, as Justice Gabriel alluded to, the possibility of grievances arising from what district attorneys do is a very real concern. Discovery violations, as this court noted in the matter of Attorney C, occur in almost every case. I believe that's almost a direct quote, and results in sanctions and other activities being directed by the courts in response to the severity of those violations.
Finish your thought. I have a follow-up question. Go ahead.
And so, to that extent, it is reasonably foreseeable that these types of things will occur. As Attorney C made it clear itself, it's reasonably foreseeable that district attorneys will have ethical violations filed against them. That happened against Mr. Ruybalid in 2 rounds. The first one, he decided to settle because he thought that was in the best interest of the county, and also because, frankly, he was being ground down by the attorney's fees since the commissioners wouldn't pay. In the second round of litigation, he took it to hearing, and he prevailed. The disciplinary judge said that all of Attorney Regulations' claims of ethical violations related to discovery violations, the same type of thing that they had alleged earlier, were unfounded. The disciplinary judge concluded that essentially Attorney C had been ignored by Attorney Regulation with respect to that second round, which was really just a continuation of the first round.
Well, Mr. Jensen, let me just follow up on your suggestion that the way we approach this should be based on the nature of the misconduct that's ultimately found. So if we take the position that discovery violations are relatively innocuous and they happen with some frequency in this environment, I wonder, do we have a line drawing problem? Do we say, okay, in another case where there's evidence that there was evidence deliberately withheld, for some malevolent purpose, or if there's a theft or lying to the court, do we take a different position, or should this also be considered, should that kind of conduct give rise to expenses that are necessarily incurred in the same manner?
So I guess I would analyze that in 2 ways. First of all, my position is that if an expense is necessarily incurred from him doing his responsibilities in prosecuting cases, that clearly falls within the parameters of the statute. I should note, Judge, that this statute is written in a way that is broadly inclusive. And if you look at the statutory history of how the statute came into being, it would support that interpretation. In the Chaffee County...
Before you go there, though, the answer to my question is yes,
Yes.
right? So there'd be coverage in that instance as well, even for this more egregious conduct, arguably more egregious.
I was actually... so let me answer the second part of your question. I'm not certain. First of all, what we'd be talking about is the most extreme example under the statute. And I'm not sure if we should be interpreting statutes to make in a fair and even-handed way, or one which anticipates the most extreme example that's not here. But secondly, in the case that you raised, I believe that there would be actual criminal law violations at play. I can think of a number of crimes that would be implicated and would be potentially chargeable if a DA intentionally concealed evidence to convict an individual. What we have is a number of statutes under the public corruption section of the criminal code, which could be applicable. I don't think that under those circumstances involving a criminal prosecution, that those would be the types of expenses that would be covered. That's where I would draw the line.
So does the rule become then that anytime someone's potentially subject to criminal prosecution for the conduct that gives rise to discipline by OARC, then there is no coverage under 20?
No, I don't know that we have to say that's the rule, that that's where a bright line is. I think really the only question we have to ask is, are these types of expenses, that is, expenses incurred in defending against a regulatory action taken by a disciplinary council, whether those are ones which are necessarily incurred in doing your job?
So can I ask you to turn to for the benefit of the counties? In what way is paying for the attorney's fees that Mr. Ruybalid incurred in defending his charged unethical conduct for the benefit of the counties?
Certainly, Judge. And so what I would note in that regard is that that is the characterization that was given by the Court of Appeals and by the court below. But that is not actually how the statute reads. And that is, if you look at the statute, it reads whether the official duties were for the benefit of the county, not whether the expenses incurred were for the benefit of the counties. And so essentially, I think what's happened here is the Court of Appeals distorted the language of the statutory provision. They didn't look at whether the activity that was being engaged in by the DA was activity for the benefit of the county. But that is the actual reading of it. Essentially, what they did is set up a straw man that is and knocked it down, even though that is not part of the fair reading of the statute or of the normal reading of the statutory provision.
So you're saying that for the benefit of such county sort of
It's the.
is equivalent to official, that it's,
I'm saying it modifies the phrase or the words directly preceding it, and that is incurred in the discharge of his official duties for the benefit of such county. And so what we're talking about is whether the official duties are for the benefit of the county, and whether this is an expense which is necessarily incurred in doing his official duties for the benefit of the county. Now,
Let me drill down on that point, because I think it's maybe where the distinction perhaps should be. In Colorado counties, that case, which you rely on, the DA in that case was sued in his official capacity as the district attorney as opposed to his personal capacity. And there are lots of cases where we talked about public officials where they get sued in their official capacities. Why shouldn't that be the line? In other words, in this statute, the county is responsible for expenses if someone has incurred expenses in their official capacity as opposed to personal. These sanctions were asserted personally against Mr. Ruybalid. If he sued personally, he was driving around on duty, and he gets in a car accident that is his fault, and he gets sued personally. I'm not sure you would say those were expenses necessarily incurred for the benefit of the county because he was on duty, but maybe you would.
I absolutely would not.
Yeah, and so why shouldn't that be the line? In other words, it's not expenses necessarily incurred for the benefit of the county if he sued sanctions in his personal capacity.
If he is sanctioned in his personal capacity, I would agree with you, Judge Gabriel. That is, if Mr. Ruybalid had been brought up on regulatory violations for driving under the influence of intoxicating liquor, or for doing an assault, or for doing dishonest things outside of his capacity, okay? And that's a line that I could live with. And certainly, I think that that is a line to answer Justice Hood's question that is kind of drawn by the language of the statute. But when we're talking about actions which stem, whether it's a lawsuit or a disciplinary action, and arise solely from his conduct of his business on behalf of the counties and the people of the state of Colorado, we have something that clearly fits within the language of the statute. And I would note something else in that regard, which relates to the American rule, is that the Court of Appeals entirely ignored the first part of that statute. A primary rule of statutory construction, one of the primary rules after the plain language rule, is the rule that every part of the statute should be given effect. All words have meaning. Well, this statute starts out by indicating very precisely that except as otherwise expressly provided, and then goes on. In other words, it's saying the only exceptions to these are if it is expressly provided in another statutory provision. The history of that probably has to do with the history of how the statute was created. And that what happened, and the Teller versus Trowbridge case, one of the first cases decided under the statute, before the statute, denied the district attorney various expenses. Essentially, the county commissioners were nickeling and diming DAs and saying, we're not paying that, there's no statute. In the Chaffee County case, the Supreme Court noted that after they issued the Teller versus Trowbridge decision, that then the legislature passed this statute specifically. It had that language to begin with that is except as otherwise expressly provided, and then indicated that necessary expenses had to be paid. In other words, they're saying, we don't want to have to deal with them claiming that every necessary expense is not something that they're responsible for. And so we're going to say that they have to pay necessary expenses unless there is a specific statutory provision to the contrary. There is none here.
Mr. Jensen, good afternoon. Let me follow up on the questions from Justice Hood. So as I understood your answers to his questions, you would agree that if there is criminal conduct while a district attorney is discharging his official duties, that would not fall within the scope of the statute. Is that right? Is that what I understood you to say?
That would be my personal opinion, because I don't believe that could be fairly characterized as being part of his official duties for the benefit of the county. That is, if I, as a prosecutor, am engaged in criminal violations, actively seeking to prosecute someone wrongfully in a way that would violate the criminal law, I think that would be outside of the scope of my employment.
Well, let's say you're having negotiations with opposing counsel and you lose it and you grab a sharp object and stick it in his arm. Now you've assaulted him, you get charged with assault, felony. Is that covered? I mean, you were acting in the district, you were in the discharge of your official duties as a DA, you were negotiating with opposing counsel, but you violated the law. You committed a criminal violation. How's that different than what we have? And how do we distinguish between the two scenarios?
Sure. First of all, I don't think that would be part of my official duties as a prosecutor. I'm confident my office would not think so, and I am fairly confident that the courts would not think so either, because that is an act which is not part of what I normally do on behalf of the people of the state of Colorado, and is so outside of that it creates criminal responsibility. Here we're talking about, in essence, we're talking about Mr. Ruybalid and his office being pursued for providing late discovery in cases, or at times having to dismiss cases or diminish charges as a result of sanctions or anticipated sanctions that are going to be imposed by courts. We're talking about something which is inherently involved in what he does day in and day out. And frankly, he did these things under an environment where the county commissioners of his county had woefully and inadequately funded him in such a way that it was extraordinarily difficult to do the normal operations of a county with that type of caseload.
Let me follow up on that, if I may. Are you finished, Justice Moore?
Please.
So again, I understand what you're telling us now. I'm not sure the extent to which that's part of the record, but I guess I find myself wondering again about what rule you're suggesting. Do we carve out a rule that says, well, when the counties have so underfunded an office that they've created a recipe for failure, then all bets are off? Is that the rule?
No. And I think the rule that was actually articulated by the Court of Appeals in the Prowers County case is one that actually makes a great deal of sense and is actually much better reason than what's by the Court of Appeals in this case, which summarily rejects that case, saying we don't have to follow an earlier decision of the Court of Appeals. That decision was decided in 2002. And that panel indicated that when we're looking at necessary expenses, they asked the question, is it reasonably foreseeable? That is it reasonably foreseeable that the activities of the district attorney in doing his official duties would result in these expenses? And there they said, the DA has to have staff, and it is always reasonably foreseeable that staff may be fired and that they might bring a lawsuit for being fired. Now, if you just follow the Prowers decision, which was on the books for 15 years until changed by this decision, and use that same foreseeability standard, which is one that the courts are actually very used to using, and look at what happened here, you'd come to the same conclusion. And that is, Mr. Ruybalid was prosecuting criminal cases.
But it's further than that, and I guess it comes back to Justice Hood's question about, does it matter what level of unethical conduct? I mean, it's reasonably foreseeable he might get grieved for something. Or you could read that to say, if we adopt the rules, reasonable foreseeable he'll engage in unethical conduct. That would seem to be an odd ruling from the Supreme Court of this state.
Well, I think it's reasonably foreseeable that grievances might be filed.
Yes, but these fees were accrued not because of a grievance that was filed. It was because the OARC, having been notified of a grievance, saw serious enough trouble that our board that regulates attorneys decided it merited following up on those grievances. And that isn't what happens in the vast majority of cases. Most grievances do not result in follow-up like this by the OARC.
So,
May I offer a friendly amendment to that,
Yes.
too? Well, and in this stipulation that ultimately came down, there was a stipulation that some of the conduct was knowing, right? So I guess address all of that, if you will.
sure. Okay, so two things. Yes, Mr. Ruybalid decided to settle this and to settle the matter with a probationary sanction, and so that he could continue to do his business as district attorney for the third judicial district. That is correct. And in that regard, part of the motivation had to do with the cost. That is, he first went to his county commissioners, asked them to defend him. They said, we'll give you $7,500. That's the extent of our liability. And then they refused to defend him any further. And so, yes, he made a decision to make these admissions, virtually all of which relate to discovery violations. Many of the claims were, at times, a number of them were years old. At times, they involved things that other attorneys had made in terms of discovery violations. None of them were shown to involve Brady material. None of them were shown to be material in nature. But this is what he defended against. And so he settled this in the spirit of these rules so that he could move on with doing his job and the business of the county. Now, I wanted to point to the court's attention to those very rules of professional conduct that we're all bound by. This is what it says in the scope of the rules, and I quote, "The fact that a rule is a just basis for a lawyer's self-assessment or for sanctioning a lawyer under the administration of a disciplinary authority does not imply that an antagonist in a collateral proceeding or transaction has standing to seek enforcement of the rule. Accordingly, nothing in the rules should be deemed to augment any substantive legal duty of lawyers or the extra disciplinary consequence of violating such a duty." In other words, the rules themselves say that he should not be penalized with respect to the availability of the application of a statute that clearly covers this situation just because we're dealing with ethical violations or admissions. That's not the purpose. He was punished in that. This goes too far, and that's what's happening here. This rule, the American rule, has been taken essentially out of thin air as it applies here. It, by its very nature, applies to cost shifting amongst litigants, not to apportioning expenses amongst government entities pursuant to a statute such as this. It has no bearing here at all. Secondly, it ignores the introductory language of the statute, which says except as expressly provided, because the American rule says the exact opposite. It says only if expressly provided are you awarded attorney's fees, whereas the provision says that as applying to this particular statute, the rule is contrary.
Mr. Jensen?
Yes.
Yeah, I'm afraid your time has run out now.
Thank you, Justice Coates.
Thank you. Thanks for your argument. Ms. Newman?
May it please the court, my name is Mary Newnham, and I represent the Los Animas County Board of County Commissioners. The two issues that this court framed when it granted certiorari can be answered by answering just one single question. And that question is, can indemnity be read into a funding statute? The answer to that question is no. What I'm seeing in the court's questions here today is this struggle to try to figure out the parameters of what funding or what indemnity would look like within a funding statute. The reason for that is it shouldn't be read into the statute in the first place, because the legislature has spoken on this area in the Governmental Immunity Act. That provides the parameters for which indemnity is provided. So because of that, I would like to actually start with the court's second issue, which is there any instance in which attorney's fees or indemnity can be provided under Colorado Revised Statute 20-1-303? To analyze this, the court needs to look at statutory construction rules, which very clearly say that the court needs to look at, one, the statute as a whole, construing it to give consistent, harmonious, and sensible effect to all of its parts. And then two, applying the clear and plain language of the statutes. Now, if a statute is silent as to a matter, if this court can still apply the statute without reading something into it, it is to do so. In In Re 2000-2001, District Grand Jury in and for the First Judicial District, 97P3D 921, this court said, if a statute can be construed and applied as written, the legislature's silence on collateral matters is not this court's concern. It is only if a statute is ambiguous that a court then goes on to look at things like legislative history, prior law, consequences of given construction, or statutory scheme. Colorado Revised Statute 20-1-303 is clearly a funding statute. If you look at where it is located within the Colorado Revised Statutes, it is located under a title that says District Attorneys. It is under a part that has to do with the compensation and expenses for district attorneys' offices. Nothing in there talks about indemnification. And in fact, the statute itself says that the DA is entitled to collect and receive from counties expenses necessarily incurred in the discharge of his official duties for the benefit of each county is the expenses. But let's be clear here, what Mr. Ruybalid is asking for is indemnification. He's not asking for the expenses of his office, like a typewriter or a computer, paper, those sort of things with which you could manage an office, but instead he is asking that the counties indemnify him for actions that occurred while he was the district attorney for the 3rd Judicial District.
How do you distinguish the Prowers County case, or you just think it was wrong?
I do think it was wrong. I think the Court of Appeals was correct to disagree with it, and I think the reason for the Prowers County outcome is exactly what I said at the beginning. I think the Court of Appeals was trying to figure out how to provide indemnity through a funding statute.
But didn't the Court of Appeals in that case all specifically talk about the CGIA and talk about how because of the CGIA and its application in that case, 303 expenses included the indemnification that was provided by the CGIA?
So what's interesting about that case is originally both the state risk pool was sued under the CGIA as well as Prowers County to provide attorney's fees that were expended by the other counties in the district in that lawsuit. And if you read the first part of the case, it says that there was a motion to dismiss the state risk pool, and then that ultimately went up to the Supreme Court to see if that was an appealable order. I was unable to find what happened to that portion of the case. So the remaining opinion there then deals with just Prowers County. And so when the court is talking about should Prowers County provide funding or provide for the attorney's fees, it seems to sort of meld in the CGIA. It doesn't actually decide it under that. It decides it under 20-1-303. And I think the purpose for that is, the purpose for the sort of melding in was because it's a funding statute. It doesn't provide guidance when indemnity or attorney's fees should be provided.
I'm not sure I understand the distinction between indemnity and expenses that you're making. You think you could stay with that a minute?
Sure. I believe that in this statute, expenses means things, again, to keep the county attorney's office open. Hopefully they'll keep that open too, but to keep open the district attorney's office. So things, again, like wages for staff, computers, paper, lights, phones, those sort of things that that the district attorney needs to do his job and perform the official duties that are actually set out in 21-1-101 at SEC. Indemnity, on the other hand, is the paying for an expense that someone else has incurred through their actions. So, for example, because he had an action and then got sued, he requested that the counties indemnify and defend him. So it's a little bit different than expending funds for the direct prosecution of a case.
Is that different from you saying that whether this is indemnity or expenses, but the money that was involved was not for his official duties?
I'm sorry, I'm not sure I understood your question.
I'm not sure I understand what the difference between indemnity and expenses is, the way you're using the terms, other than you seem to be saying if it was money that was expended for, and then you're describing things that
I'm sorry,
I guess I'm asking, are you saying the reason that that's indemnity and not expenses is those weren't for his official duties on behalf of the county?
Yes, yes. So the funds that would be expenses would be those expenses actually needed to prosecute cases on behalf of the county. Where indemnity is asking the counties to pay for his attorney's fees after a claim is brought against him, such as a lawsuit or a disciplinary action, right? And then it very similar to like an insurance situation, right? You have insurance to pay if you are sued, and it pays your defense and it indemnifies you for any judgment or settlement that may come from that.
It's the fact that these would be attorney's fees incurred as a result of him being sued.
Yes.
But that wouldn't necessarily mean attorney's fees could never be expenses?
I would agree with that. I would agree. I think the difference there are the attorney's fees to pay for a personal lawsuit against you or for something that's the function of the office. So, for example, paying your deputy attorneys their wages, right? Those would be attorney's fees. Those would obviously be an expense of the office. Or if you had maybe another situation where a district attorney maybe consults an attorney on how to prosecute a case and maybe pays a fee for that, I think that could be an expense of the office.
You seem to disagree with the notion that paying attorney's fees to defend against a personnel action would be expenses. What if it was to bring a personnel action? Would that be expenses?
Potentially, I think that could be. If you were bringing, if for some reason the district attorney's office had to, I'm trying to think of what that would be, but had to sue employee maybe for embezzlement or something like that, potentially, yes, that would be an expense of the office.
Can I jump in there? What if they had something they anticipated to be a personnel matter and they consulted an employment lawyer? Would that be indemnification or would that be an expense?
I think that would, I believe it or not, I think that would be an expense. I think one of the differences here is actually having a claim brought against you. I think consulting to try to figure out how to best run your office, right, and maybe to avoid an issue could potentially be an expense.
But not all claims are sound. I mean, you may fire somebody for great cause, but they sue you, meaning the DA, individually and in your official capacity. It could be as frivolous as, as it goes. And you're saying the DA is out of luck, they got to personally fund their defense.
No, that's not what I'm saying. I'm saying that they cannot fund it through 20-1-303. There is a mechanism through the Colorado Governmental Immunity Act that they could potentially seek recovery of those, or seek recovery of any settlement or defense costs.
Because it's a tort? I mean, I'm guessing.
Well, it depends on the claim that's brought.
Well, may I jump in?
Please.
A couple of things. First of all, can you respond directly to Mr. Jensen's argument that Mr. Ruybalid needed his ticket in order to practice law and be the elected DA for the judicial district? So he is characterizing that as a necessary expense in the sense that you're using it, if I'm understanding his argument correctly. So can you?
I disagree that, well, I agree that a district attorney needs a law license, right? But it was not necessary that he continue on to be the district attorney. There are always instances in which elected officials do leave office and someone is appointed. Now, I know that that may not be the person that's elected, but it does happen. And so I do not believe he had to do it so he personally could remain in office. That ultimately was his choice, and that's fine if that's a choice he wants to make. But at the end of the day, I don't think that he can seek the recovery of attorney's fees from the county for that.
I also just want to make explicit what seems to be implicit in your argument, and that is that you don't seem to agree with the Court of Appeals' reliance on the American rule.
I believe the American rule has its place as being informative of the analysis, and that's exactly what the Court of Appeals said, is that it is informative. And I think that in the silence of the statute regarding attorney's fees, that's where the information comes in. And then there's that idea that the court doesn't read in stuff into statutes that the legislature hasn't put in there. And I think in that respect, the American rule is at play, or at least is informative, not necessarily at play here in this analysis. In fact, one of the cases involved People versus the District Court, City and County of Denver, regarding a criminal procedure rule and discovery sanction. The trial court ruled that the prosecutor's office need to pay the attorney's fees of the defense. And this court decided that no, there was nothing in that criminal procedure rule that allowed for attorney's fees to be recovered. In fact, that rule said in there, it had a catch-all provision at the end that says, or enter other orders as it deems just under the circumstances. This court went so far as to say even that catch-all provision doesn't include attorney's fees in this situation. In coming to that analysis, this court noted that payment of attorney's fees from public funds should be viewed with even greater rigor than the payment of attorney's fees normally under a situation such as the American rule. Specifically, this court said, an award of attorney's fees to be payable from public funds implicates sensitive budget and funding considerations, and authority to intrude into these areas is not to be lightly implied.
In the interest of moving things along, assume for the moment that you don't prevail on your argument that it's the CGIA or bust. And we do think that 21303 has some application here. What's your second line of argument?
The second line of argument would go to this court's second issue regarding whether the expenses were, what was pled was sufficient to show that they were within the official duties or for the benefit of the counties.
Talk to us about that, please.
In deciding whether sufficient facts were pled to show that it was within the district attorney's official duties in defending the disciplinary action, this court should take note of 20-1-101 at SEC. It is the first part of the same title that this funding statute is under. And under that first part appears all of the official duties for district attorneys. It lists things such as their bond, their appearance on behalf of state and counties, to collect forfeited recognizances, appear at inquests, those sort of items. Nothing within that statute says anything about defending disciplinary proceedings. In fact, if you look at the complaint filed by Mr. Ruybalid, he doesn't assert any facts that show that the disciplinary proceedings fall within his official duties. Now, he does attach a stipulation that has many facts regarding stuff he did or didn't do within his official duties, depending on how you characterize the stipulation. But that is not the same as the defense of a disciplinary action, which is not necessarily an official duty.
So assuming that 20-1-303 applies, can you envision any scenario in which a district attorney would be entitled to recover expenses for attorney fees and litigation costs?
Again, not necessarily under that statute.
So you don't think that attorney fees or litigation costs would ever be available under that particular statute, correct?
No, not if he was sued personally. Again, maybe if there was an instance in which a DA needed to bring a lawsuit, but to be sued personally, to have those costs in there, I don't believe so. Potentially, I guess also potentially if the office itself was sued and not personally.
But under no circumstances a disciplinary proceeding.
And exactly, under no circumstances a disciplinary proceeding.
What if, thinking of a scenario, let's say that the DA and the county commissioners get at odds, and the county commissioners consciously decide to underfund and cause, an inability to complete their duties, and including discovery, and then that results in the grievance. Even under those circumstances?
Yes, even under those circumstances. There's a mechanism in that instance in which a district attorney can, before it ever gets to the point of having ethical violations, the district attorney can take the boards of county commissioners to court to seek additional funding. In fact, it's happened down in Los Animas County before with one of the predecessors in the DA's office. If it is underfunded, they can seek additional funding without it ever getting to this point.
Well, are you finished? I guess I'm sympathetic to part of Mr. Jensen's argument when he says, discovery violations occur, it's kind of part of the arena, these things happen, and that is an expense of the office in a sense because it is foreseeable. Can you respond to his argument that we should adopt or engraft some kind of reasonable foreseeability? Right? And then I guess secondary to that is this reasonably foreseeable if we were to use such a standard?
One, I don't think foreseeability can be read into the statute. I think that's exactly what the Prowers County case was trying to do, and I think that is stepping on legislative intent. So I don't believe that even those sort of proceedings would fall under 20-1-303. Now, if this court was to find a foreseeability standard and import it into 20-1-303, I still do not believe that this would fall under that. To say that just by being the district attorney, you would face ethical charges, and that those ethical charges would be actually brought to a claim by the regulatory council and then enter into a stipulation, that's a lot of steps to go through to actually say that this would be foreseeable.
Right. You just went through a number of steps in getting, you went all the way to stipulation, but you could certainly foresee circumstances in which there might be grievances, maybe even some that survive intake, which might require retaining counsel, and it still could conceivably be part of the ordinary business of the office, in a sense. You're dealing with these kind of discovery issues all the time. You're dealing with very contentious cases where people have an incentive to come after you.
But again, even though it may be foreseeable, right, that you would have an ethics complaint brought against you, I still don't believe that that imports then a duty to defend or indemnify into that portion of the statute. If the legislature wanted that, the legislature, I think, was spoken on that. And similarly with the CGIA, if it wanted to allow indemnification for these types of cases, it would allow it through the CGIA.
But not all claims are necessarily tort claims. In other words, there might be a breach of contract claim. Let's say the office failed to pay an expert or something like that. I mean, I could see that situation where the DA sued in his official capacity for failure to make that payment. How would that play into your framework?
I think that's the same discussion I was having just a second ago with the other justices. There may be a situation where the office itself is sued, for example, like a breach of contract, that may allow for attorney's fees, but I still think the individual being sued could not fall within an expense of the district attorney's office. One last point, unless someone has a question, I'm sorry, just
I know you're
quickly.
trying to let your co-counsel-
Mr. Sheldon might like to speak as well. The final point to this is just to reiterate that we do not believe that even the official actions that were not taken or taken fall within a benefit for the county. Counties do not benefit, nor does the public benefit when there are ethical violations. Instead, those ethics and canons are there to protect the public, and so therefore we don't believe there's a benefit. We would request that this court uphold the appellate court's decision and the dismissal of this case. Thank you.
Thank you. My name is Garrett Sheldon. I'm the Werfenau County Attorney, number 3275. I think we can get back to basics here and just talk about, no matter where we go, we always do the grand circle and come back to the interpretation of 20-1-303. And there's a three-part test that I think applies. Expenses were necessarily incurred in the discharge of his official duties for the benefit of such county. Webster's defines benefit as something that guards, aids, or promotes well-being, an advantage, something equal to good. And I found that downstairs in Webster's third. Black's defines it as advantage, privilege, profit, or gain. As part of the, and I will, just as, before I get there, 22 counts were dismissed as part of this settlement of the stipulation. And I think that I have to assume that they were some of the nitpicky things concerning discovery. There were dozens of complaints left. He also agreed to pay $23,000 in cash. But the stipulation had an agreement that his misconduct caused actual harm to the administration of justice. And that's in the record on page 34.
But it said that it wasn't willful, correct? Didn't it? Wasn't there a stipulation that?
Right, nothing was willful, and the conduct was not willful, but was negligent. Knowing, I think, was part of it. But it wasn't, you're right. But we're
Counsel,
talking about the causation here.
Can I ask, can you speak to the argument made by opposing counsel that the "for the benefit of the counties" refers to official duties for the benefit of the counties rather than asking whether the expense was incurred for the benefit of the counties?
Well, it has to be in the discharge of his official duties. When you're not doing your duties in courtroom, I don't think those are official duties. It's just, and they don't benefit anybody, and they're not official duties. Your official duties imply the competent presentation of cases, and I just don't think that it benefits the county or is in the discharge of its official duties. There are so many things stipulated in these things, and as an aside, I've never seen a case like this. Perhaps you haven't either. There are one or two misconducts and attorney is suspended or something, but in this case, it's case after case after case.
Could I ask you a question still on official duties and for the benefit? Do you think that, would you see that concept in this statute as being related at all to the notion of scope of employment? If he was acting within what we would say was the scope of his employment, would that mean he was doing an official duty? Or, as I think I'm hearing you say now, no, not necessarily.
Not necessarily, yeah. I mean, when you're, are you in the scope of your employment? I'll answer your question with a question. If you're in the scope of, are you in the scope of employment when you're not doing things properly in the courtroom?
And yet, and I partially pick up on this line because both the other counsel, I think, at various times referred to, or we asked questions concerning foreseeability that seemed to me to raise at least maybe an analogy of agency theory or respondeat superior law. Does that have any application here in deciding whether he was acting? And in the event he didn't do his duty because of negligence, would that still be within the scope of his employment?
Yeah, that's a good question. I don't really have an answer to it. But I note, and I want to get this in, that the trial court mentioned in its summary or its conclusion that these offenses were personal in nature. And maybe that's the test. You come into the office, you know, you talk about agency, I'm talking about marital law. You come into a relation, you come to the office with certain things that are yours. Your license to practice law, your driver's license, all those things. And you leave with those same things. And so if they're personal in nature, I think you have the responsibility to protect them and to pay for their protection.
I guess the only problem with that is that sometimes they overlap, right?
Yes.
And Mr. Jensen would say that this is one of those times, so
Well,
what do you do with that?
Your license to practice law is personal. It's, when you get disciplined, it's personal, and that can be taken away from you. And he actually still has that license to practice law. When he goes out into what I call the real world, he still has that license. He still can practice law. And when he leaves the office, he takes things out of that office. His law degree, his college degree, his license to practice law, his driver's license, the potted plant, you know, everything. That's how I draw the distinction. It's something that the trial court mentioned, and I think that might be a way to distinguish one of the tests anyway. But I just don't think that, they presented their case. We agree with there's two ways you can analyze this. One is just to look at the Court of Appeals opinion and just say, look, if the statute doesn't apply, the American rule, if it doesn't give you attorney's fees, then you're not entitled to them, period. We need to go no further. Now, if you want to go further and do the analysis of 303, I think there's a three-part test there that we said should be applied. And my way of analyzing it is if he comes into the office with those things, leaves with those things, he has to defend those particular licenses. We're not obligated to defend Mr. Ruybalid in his personal life, and this is personal in nature. I don't have anything else to say. I've got a minute, 30 seconds, so.
You're not obligated to use it.
I thought you might appreciate that.
Thank you, we
Thank you, Mr. Schell.
appreciate it. As a matter of fact, we appreciate the arguments of all the counsel who have argued here today. This case will stand submitted, and the court will be in recess.